GDPR excellence, protecting personal data and building lasting public trust. In a world shaped by digital communication, online services, artificial intelligence, and constant information exchange, personal data has become one of society's most valuable assets. Names, addresses, identification details, financial records, photographs, online behavior, and health information can all reveal important aspects of an individual's identity and private life. The General Data Protection Regulation, commonly known as the GDPR, provides a legal and ethical framework for protecting this information. However, genuine GDPR excellence involves much more than avoiding penalties or completing compliance documents. It requires organizations to treat privacy as a fundamental right, demonstrate accountability, and build a culture in which personal information is handled with care, fairness, and respect. The European Commission confirms that data protection is a fundamental right under European Union law. The GDPR strengthens that right by giving individuals greater control over their personal information and establishing clear responsibilities for organizations that collect or use it. European Commission 2026. When organizations protect privacy consistently, they do more than comply with legislation. They earn confidence, strengthen their reputation, and establish lasting public trust. Understanding the purpose of the GDPR. The GDPR came into application on the 25th of May 2018 and applies to the processing of personal data within its territorial scope. It can also apply to organizations outside the European Union when they offer goods or services to people in the EU or monitor their behavior. Its central purpose is to ensure that individuals remain protected when their personal information is collected, recorded, organized, stored, shared, analyzed, or deleted. The regulation applies to both digital and paper-based information whenever a person can be identified directly or indirectly. Personal data may include a person's name, identification number, location, email address, photograph, online identifier, or employment information. Certain information requires even greater protection. This includes data concerning health, racial or ethnic origin, political opinions, religious beliefs, trade union membership, genetics, biometrics, and sexual orientation. GDPR compliance must therefore begin with a clear understanding that organizations are not the owners of personal data. They are its temporary custodians and must use it only for legitimate, clearly defined, and lawful purposes. The 7 Principles of Responsible Data Processing, Article 5 of the GDPR, establishes 7 essential principles that guide the responsible processing of personal data. These principles form the foundation of effective data protection governance. Lawfulness, fairness, and transparency. Every use of personal data must have a valid legal basis. Individuals should be treated fairly and informed in clear and accessible language about how their information will be used. Transparency should not be hidden behind lengthy policies or complicated legal terminology. People must be able to understand what information is being collected, why it is needed, how long it will be retained, and with whom it may be shared. Purpose limitation. Personal data should be collected for specific, explicit, and legitimate purposes. It should not later be used in ways that are incompatible with those original purposes. An organization cannot collect information for one reason and quietly reuse it for an unrelated activity without first establishing an appropriate legal basis and providing the necessary information to the individuals concerned. Data minimization. Organizations should collect only the information genuinely required to achieve a legitimate purpose. Collecting excessive data simply because it might be useful in the future increases both privacy and security risks. Data minimization encourages organizations to ask an important question: do we truly need every piece of information we are requesting? Accuracy. Personal information should be accurate and, where necessary, kept up to date. Inaccurate data can lead to incorrect decisions, unfair treatment, operational problems, and a loss of confidence. Organizations must provide appropriate procedures through which individuals can request the correction of incomplete or inaccurate information. Storage limitation. Personal data should not be retained indefinitely. Organizations need clear retention schedules explaining how long different categories of information will be kept and what will happen when that period expires. Information that is no longer required should be securely deleted, destroyed, or anonymized unless a legal or legitimate reason justifies its continued retention. Integrity and confidentiality. Personal data must be protected against unauthorized access, unlawful use, accidental loss, alteration, destruction, or disclosure. Appropriate protection may include encryption, access controls, secure passwords, reliable backup arrangements, staff training, confidentiality procedures, and effective incident response plans. Security should be proportionate to the sensitivity of the information and the risks faced by individuals. Accountability. Accountability requires organizations not only to comply with the GDPR, but also to demonstrate how they comply. Policies alone are insufficient if everyday behavior does not reflect them. The European Commission describes accountability as a cornerstone of the GDPR. Organizations must be able to show that their decisions, systems, and working practices respect every data protection principle. European Commission 2026. Consent is not the only lawful basis. A common misunderstanding is that all personal data processing requires consent. In reality, the GDPR provides several possible lawful bases. Depending on the circumstances, processing may be based on consent, a contractual requirement, a legal obligation, vital interests, a task carried out in the public interest, or the legitimate interests of an organization or third party. Consent must be freely given, specific, informed, and unambiguous. It should involve a genuine choice and a clear affirmative action. Individuals must also be able to withdraw consent as easily as they gave it. Organizations should never use consent automatically when another lawful basis is more appropriate. The correct basis must be identified before processing begins and communicated transparently to the individuals concerned. Respecting the rights of individuals. The GDPR gives individuals important rights over their personal information. These include the right to be informed, the right of access, the right to rectification, the right to erasure in certain circumstances, the right to restrict processing, the right to data portability, the right to object, and rights relating to automated decision-making and profiling. These rights are not administrative inconveniences. They are essential protections that help individuals maintain control over information connected to their identity, choices, and private lives. An effective organization should therefore have clear procedures for recognizing, recording, and responding to data subject requests. Staff should know how to direct a request immediately and should never dismiss or unnecessarily delay an individual seeking to exercise a legal right. The Information and Data Protection Commissioner in Malta provides detailed information about these rights and supervises compliance with the GDPR and National Data Protection Legislation, IDPC 2026. Privacy by design and by default privacy should be considered from the earliest stage of every project, service, or technological system. This approach is known as data protection by design. Before introducing a new process, organizations should examine what personal data will be collected, why it is necessary, who will have access to it, and what risks the processing could create. High-risk processing may require a data protection impact assessment before implementation. Data protection by default means applying the most privacy-protective settings automatically. Individuals should not have to search through complicated menus or forms to prevent unnecessary collection or disclosure. The European Commission highlights measures such as pseudonymization, encryption, restricted access, and short retention periods as examples of embedding privacy into organizational systems and decisions. The human element of data protection technology plays an important role in information security, but many privacy incidents originate from ordinary human behavior. An email may be sent to the wrong recipient. A document may be left unattended. A password may be shared. Confidential information may be discussed where it can be overheard. This is why GDPR excellence depends on people as much as policies and software. Training should not be treated as a once-a-year formality. It should be practical, continuous, and relevant to employees' actual responsibilities. Staff should understand how to recognize personal data, report a possible breach, use secure communication methods, and respond appropriately when an individual exercises a data protection right. Leaders must reinforce the same expectations through their own behavior. A culture of privacy develops when employees see that confidentiality and responsible information handling are taken seriously at every level. Managing personal data breaches. A personal data breach is not limited to cybercrime. It can involve the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. When an incident occurs, speed and accuracy are essential. The organization must contain the incident, assess the possible consequences, document what happened, and determine whether notification is legally required. Where a breach is likely to result in a risk to people's rights and freedoms, the relevant supervisory authority generally must be notified without undue delay and, where feasible, within 72 hours of the organization becoming aware of it. Where the risk to individuals is high, the affected people may also need to be informed. Employees should be encouraged to report suspected incidents immediately. A blame-focused culture may cause people to hide mistakes, while an accountable learning culture supports rapid reporting, investigation, and improvement. GDPR and artificial intelligence. Artificial intelligence has created new opportunities, but it has also introduced complex privacy challenges. AI systems may process enormous quantities of information, identify behavioral patterns, and generate decisions or predictions that significantly affect individuals. Organizations using AI must still comply with fundamental GDPR requirements. They should identify a lawful basis, minimize the data used, provide appropriate transparency, and assess the risk of discrimination, inaccuracy, or unfair automated decision-making. Human oversight remains essential, particularly when automated systems influence important decisions. Innovation should never be used as a justification for abandoning fairness, dignity, or accountability. The European Data Protection Board continues to provide guidance on the relationship between data protection, emerging technologies, artificial intelligence, and digital innovation, EDPB 2026. From compliance to organizational excellence, basic compliance asks whether an organization has privacy notices, policies, and security measures. GDPR excellence asks a deeper question. Does the organization consistently respect people and protect their information in practice? An excellent privacy culture can be recognized through clear leadership, defined responsibilities, regular risk assessments, accurate records, effective staff education, and transparent communication. It is also demonstrated by the willingness to investigate weaknesses, learn from incidents, and improve systems before harm occurs. Public trust is difficult to gain and easy to lose. One careless disclosure or misleading practice can damage confidence that took years to establish. In contrast, organizations that communicate openly and handle information responsibly demonstrate reliability, competence, and respect. Privacy, therefore, becomes more than a legal responsibility. It becomes a measure of organizational integrity, the leadership responsibility. Leaders influence whether data protection becomes a living organizational value or remains a collection of documents. They must allocate appropriate resources, clarify responsibilities, and ensure that employees feel confident reporting concerns. Leadership also requires balancing operational objectives with the rights of individuals. Efficiency must never become an excuse for excessive data collection, unnecessary access, or weak security. The data protection officer, where one is required, should be appropriately involved in decisions concerning personal data processing. The role should remain independent, receive senior-level support, and have access to the resources necessary to monitor compliance effectively. Ethical leadership means asking not only whether an action is legally permissible, but also whether it is fair, necessary, and respectful. My personal reflection. From my perspective, GDPR excellence begins with recognizing that every record represents a human being. Behind each name, number, email address, or digital profile is a person who expects their privacy to be respected. I believe that confidentiality must never be treated as a routine administrative obligation. It is a professional and ethical responsibility that reflects the values of an organization and the integrity of its leadership. As a leader, I would promote clear procedures, continuous education, and personal accountability. I would encourage employees to question unnecessary data collection, report concerns immediately, and consider the possible human consequences of every information handling decision. Public trust cannot be demanded. It must be earned. It develops when people see that an organization communicates honestly, protects their information, and responds responsibly when something goes wrong. For me, GDPR excellence means creating a culture in which privacy is respected, even when nobody is watching. That is the point at which legal compliance becomes ethical leadership. Conclusion. The GDPR transformed data protection by placing individual rights, organizational accountability, and responsible information use at the center of modern governance. However, genuine excellence cannot be achieved through policies alone. It requires knowledgeable employees, responsible leadership, secure systems, transparent communication, and continuous improvement. Organizations that view GDPR solely as a regulatory burden may achieve minimum compliance. Those that embrace privacy as a fundamental value can achieve something far more meaningful: stronger relationships, greater credibility, and lasting public trust. Protecting personal data ultimately means protecting people. When organizations understand this responsibility, GDPR becomes not simply a regulation to follow, but a standard of excellence to uphold. Reflection question: how can leaders ensure that data protection becomes part of everyday organizational culture rather than merely a compliance exercise? Leaders can achieve this by modeling responsible behavior, providing practical and continuous education, defining clear responsibilities, and encouraging employees to report mistakes or risks without fear. Privacy considerations should be included in every new service, process, and technological decision. When leaders consistently connect data protection with dignity, ethics, and public trust, employees are more likely to treat it as a shared professional value. This article is the intellectual property of Mary Lourdes Bonnici, MBA. Unauthorized copying, reproduction, or republication is prohibited without prior written permission. This article is provided for educational and informational purposes and does not constitute legal advice. Thank you for your support, and I hope you enjoy this lesson.